Judge Northcutt. Attorney
Yes.
Aiello is in the panel side. He just needs to turn on his camera and his mic.
Can you hear me now?
Can hear you and see you, Mr. Aiello.
I think we're all set. May we proceed?
Absolutely.
And may it please the court, I'm Jack Aiello. I'm here representing the appellant plaintiff. And you just read the name of that plaintiff, NCW, PCS, and so forth. I'm going to try to quickly dispose of the complicated names.
No, I want you to say that 3 times fast.
Can I do that on opposing counsel's time? So NCW PCS is the plaintiff and was the tenant with respect to the site lease at issue here. So I'll just say tenant. Mr. Keene, one of the defendants, was the landlord until he sold the property in 2020. He'll be the landlord. And the company that he entered into the lease agent agreement with, which was labeled easement and assignment, that was CTLA, Unison. We'll call them the agent. That makes it easy.
Okay, so let me come right off the bat, because
Sure.
this case is a lot of moving parts in this case.
Okay.
You know, but is there an argument to be, you know, and one of the issues is like whether the lease extension went to August 2020 or to what, 2035?
2037, correct.
2037?
Right.
There's no question that the easement agreement that appointed the agent limited that agent's authority to extend the lease, correct?
Beyond August 2020, but it didn't limit it per se. It just said that the agent had to go to the landlord and get permission from the landlord.
Well, I would contend that would be a limitation on on the agent's authority to act, correct?
The condition on the agents, that's correct.
And my understanding is the record is clear that that written permission was not obtained.
Well, no, it's not clear. That was an assumption. That is still being litigated in the eviction case.
Well, is there any contradiction to Keene's testimony that he was unaware that lease had been extended beyond August 2020 until he was deposed?
Keene never saw the lease and didn't remember entering into the easement and assignment agreement. But then his testimony was, I just know this thing wasn't supposed to go beyond 2020.
And but there's been no evidence of a written permission.
No one has presented a written statement back from 2007.
Okay, because the party's arguments rely somewhat on how long that lease was extended to. And one of the possibilities being, or it was good, to August 2020. But isn't there, and no one, and I'm raising this because I haven't seen it briefed in all the gray paper I've been reading in this case. But there's an argument that the lease terminated in August 2020 because that permission was not granted. But could there be a possibility that lease extension was invalid?
Well, that's the implication of the order the judge signed, right?
Well, but didn't the judge find that the tenant had breached the 07 agreement? I mean, the 85 lease by extending it, even though, you know. So yeah, I'm proposing a right for the wrong reason.
Okay, I think that's the import of the judge's ruling. I think he's saying that
He's saying the lease extension was not valid because it was a breach of the 85 lease.
Because the agent didn't come to the landlord to get permission
Right.
beyond August.
But even if you don't treat it as a breach of the 85 lease, it is theoretically, arguably, an extension of the lease that the agent had no authority to enter without the written permission of Mr. Keene.
That's correct. Now, keep in mind that extension was actually 6 5-year extension.
I understand,
Right.
But none of those 5-year periods add up to August 2020. August 2020 was the termination of the agency appointment.
You would have been in the third 5-year extension on
You
August
wouldn't have
25.
been at the end of the
Not at
5-year.
the end of it. That's correct.
So there's no way to read that lease extension as terminating in August 2020.
Well, except that if you say that the agent only had permission to extend the lease to August 2020, it would automatically then terminate on that date.
You think?
Well, you'd have to
would that be the case, or would the extent of or the lease extension that extended the lease beyond August 2020 be an act beyond the agent's power, and therefore the lease extension is invalid? See, that's the potential right for the wrong reason that no one has been arguing.
Well, I mean, I think that's
and ergo, if the lease extension was invalid, then the right of first refusal was lost at that time.
the judge is saying I believe the right of first refusal was lost.
He did, but he said the tenant breached the 85 lease, and therefore the right of first refusal was lost.
Okay, and that doesn't make sense because it was the 87 lease, and there's no term in the 87 lease that even talks about it.
I'd say in 87.
Correct. But there's no term in the 87 lease that even talks about.
No, I understand.
Right.
I understand.
So this tenant did not breach the 1987 lease. The only thing that was done against any of these agreements was possibly against any is the agent entered on behalf of the landlord, entered into an extension with the tenant that potentially went beyond 2020. That's the only, and
contrary to the terms of the agency appointment.
With terms of the deal between the agent and his landlord and the landlord. Correct. The tenant wasn't a party to that agreement. Nobody came to the tenant and said, I'm entering into this agency agreement. Will you be responsible to make sure that the agent performs his duty in the event?
Okay, but we can flip the coin on that. The other side of that is you were aware of the 87 easement agreement. All these terms kind of get conflated, but you were aware because that was recorded, right?
The 87, there was a memorandum.
I just lost your sound.
I don't know what to do about that. Can you hear me now?
Still
No.
can't hear you. Sorry.
Can you hear me, Judge Lucas?
Hold on just a second.
Yeah.
Sounds
I
like
can hear
maybe
you.
not.
I can hear you, Mr. Aiello.
Okay, I think we've lost.
Mr.
Well, I'm seeing you all talking, but I can't hear
All right.
anything. So I guess there's
We are
not
going
much.
to. I'm going to stop the clock because we have people who can go help Judge Lucas, hopefully, and we'll
Okay.
resume. Sorry,
Thank you, Judge.
we've been having these problems all morning.
Judge Northcutt, could you say something, please?
I could, but I won't.
All right, we're good. Thank you.
Are you back with us, Judge Lucas? Can you hear? You're muted.
Yes, I'm here.
Okay, so
Can you
we're
hear
ready.
me?
Yeah, I can hear you. All right, we're ready to go. Mr. Aiello, I have you at about 7 minutes in.
Okay,
Does that sound right to you?
that seems right.
Good enough. All right. You have at it.
Okay, so the agent had the authority to enter into leases that go to the full extent of the time of that agency agreement, which was August of 2020. Nobody consulted the tenant or asked the tenant to police the agency agreement. And if a third party could be forced to do that, we wouldn't deal with agents, right? It would change the commercial landscape. And that's what,
If the third party is on notice of the agent's limitation, then the third party isn't the law. The third party can rely on the agent unless there's, unless the agent, the third party is aware of the limitation of the agent's authority.
we have seen no case presented that makes the tenant, the third party, responsible for the performance by the agent of its duties to the landlord. None. The other side has presented none. This is not an interest in land. An easement is an interest in land, but this part of the agreement is part of the assignment of the right to lease the property.
Yeah, which was in an easement agreement.
It was in a recorded
And
agreement.
which was the basis of the agent's dealings with the tenant, correct? I mean,
Correct.
The easement itself would not have done that. I mean, there had to have
That's
been
right.
this agent.
Right. So
And I do have to wonder, Mr. Ayala, that wouldn't be an issue of due diligence, and that wouldn't be an issue, a closing issue prior to entering into a lease with the agent when you're on record notice of knowing who the fee owner of the property is, who it is that has the ultimate authority to grant the easement. To make it a much more simple example, it would be unheard of to rent an apartment and have the leasehold in the property manager's name and not the corporation or company that owns the actual apartment. I mean, that would be, one would flag that as unusual and would rightly wonder, by what authority the agent has to bind its principal to a leasehold of the agent's real property. So why isn't that fair game to question?
well, let's just assume that the tenant saw this document. It was of record. They may not have any real reason to look at the record. They already had a lease, but let's just assume they are charged with knowledge of this document. It still says that if there is going to be an extension beyond 2020, it's up to the agent to get permission from the landlord. We don't have to solicit that. We don't need to see a copy of it. It doesn't put any duties on the tenant. And it does authorize the agent to extend it to at least August 2020. What happened after this agreement, right, and after the 2007 extension, is that the landlord accepted the rents for 13 years.
But the landlord accepted the rents from the agent because under the agreement, the rents were paid to the agent, correct?
Correct. But how can we charge the tenant with knowledge of what's going on between the landlord and the agent, but not charge the landlord with knowledge?
Well, the thing is the question of whether that was a valid lease extension is not a matter of whose fault it was.
Right, but void ab initio means that the parties they got to seek in some timely way to void it. They accepted rents for 13 years and acted like it was valid. If they had a problem with the term of the lease, they should have come to the tenant and said, we don't want to extend this beyond 2020, and given the tenant an opportunity to say, no, then I don't want to do it at all. Waiting 13 years and accepting the rents, and it goes beyond that. Mr. Keene, with his deposition was taken, he never even read this document, the easement and assignment. He never read the lease extension agreement. He said, I don't read those things. I have lawyers for that. And why don't you read them? It's not worth my time. I have other things I like to do. I like to watch my grandchildren's baseball games. I don't read that.
Well, but he knew that there was that August 2020 limitation.
Maybe, if you read his deposition, I'm not sure you would come away with that opinion, but maybe. And so when you say he knew that, without even looking at if you knew you were going to be getting income from a lease extension, wouldn't you at least look at it and see how much am I getting? How many years am I going to getting that? He did nothing to protect his own rights. And the only time it became an issue was 13 years later when he sought to sell this property and the purchaser wanted to get rid of that lease or change that lease. And then the lawyers pulled this one sentence out of that big fat paragraph in the easement and assignment agreement that says the agent had to consult the landlord. So under those circumstances, the tenant fully performed for 13 years. Nobody says a word to the tenant about there being a problem. The landlord doesn't raise an issue. How can the tenant be charged with responsibility for the agreement between the agent and the landlord?
Well, I'm not suggesting that the tenant is charged with anything. I'm suggesting the possibility that the lease extension was not valid because of the failure of that condition precedent.
But doesn't it have to be declared not valid, and doesn't somebody have to speak up? I mean, it's the landlord who was harmed by the agent's action, assuming that happened. Shouldn't the landlord speak up rather than accept the rents for 13 years? The landlord didn't
Just have a holdover.
I mean, and it says
That's good. I mean,
and the provision of this extension says, and I want to pull this up because I had some concerns about this language. And I'm not sure what it means. Lessor and lessee have been advised and are informed that should lessor not enter into this amendment, and I'm not sure who the lessor is, the underlying, that reference is to Mr. Keene or to the agent. The underlying lease between lessor and lessee, including any termination or non-renewal provision, would remain in full force and effect unless he would revert to month tenancy. So it could be he was accepting what he thought were month to month.
Well, there's no testimony to that effect. His only testimony is I never read the agreements. I counted on my lawyers, and his lawyers never brought to him any problem about the site lease. He didn't ask the tenants for a copy of the lease. Why would he?
What I'm saying though is your client and your client's payment of lease payments is not inconsistent with the expiration of the 2007 lease.
Except the lessor did enter into it. Right. The provision you're reading, it refers to what happens if they don't close on this lease extension. Well, they did. We have the document. The lessor did enter into it. Now, the question is whether is it foreshortened to August 2020 because that's all the authority the lessor, we don't even know today whether the agent got permission from Keene. That's being litigated in the other case. The judge just assumed based on the lawyer's argument. Remember, there's an eviction case going on and a case against that agent, and it's still pending.
Oh, I know.
Yeah. So we don't even...
but for the complete elimination of Mr. Keene from this litigation, I don't think we would have an appealable order at this point because of the interrelated issues.
There's a good argument to that effect. I think we made that argument once, but the judge entered a final order anyway. But you're right. Keene and DNB are out of the case, so there is a final order.
So there is a final order.
Yes.
But for that, this case is completely, well, not completely, but largely interrelated with the still pending litigation, correct?
That's true. That is true. So this provision in the easement and assignment agreement, the one we were talking about, still says property and the site owner will be bound by such lease agreements throughout the term of this agreement, right? And so even if the landlord had the right to go back 13 years and say that lease extension goes too far, there's no basis upon which he could say it was void ab initio, right? He didn't act that way. He didn't do, it's not fair to the tenant to remain silent for 13 years and then say, oh, by the way, that was really void ab initio. We're keeping the money, but you don't get your benefits under the agreement. You don't get your right of first refusal.
I'm not sure it's a void ab initio issue as much as just you carry on with a month-to-month holdover tenancy, which is, that's not void.
Well,
right.
That would void the written document though, and that's the document the tenants rely on.
It's not void, but it's not void. It's just expired. It's terminated. And there's a difference between those terms.
Right.
I mean, it doesn't matter to you, but it does matter.
Yeah, although they signed a new lease extension, what happens with that if you don't void it, right? It's there, the document is there. And so if you're going to proceed on a month-to-month and not that document, you have to do something.
But can I ask you a question about one of the more discrete points of one of your arguments?
Sure.
Typically, a right of first refusal will look to the point in time of receiving an offer or a contract.
Yes.
In your brief, though, I seem to recall reading an argument that you're saying you suggest that for purposes of timing, we really should look to for purposes of when a sale occurs, not to when a contract is offered or an offer is made, but when a fully completed closing with a transfer occurs. And that struck me as a little bit unique, at least in the world of rights of first refusal. Can you point me to a case that applies that kind of definition of what a quote unquote sale is in the context of a right of first refusal?
The right of first refusal isn't triggered by a sale, it's triggered by an agreement to sell. And when the landlord, right, okay, so there are two different things. If you have a home under contract, but it doesn't close, did you sell it? No, you didn't sell it. Something went wrong. You had an agreement.
That's non sequitur for the right of first refusal, because the only thing the right of first refusal really cares about is when did you get a contract or an offer to sell?
When you get an agreement to sell, then it has to be extended to the tenant. That's correct. But
okay,
but the landlord doesn't.
What you're suggesting, Mr. Aiello, is that the injury, whatever it is, occurs when the property is transferred without having extended that right of first.
And that is what I was saying. There is no deadline as to when the landlord has to extend the offer to the tenant. So it goes right up until he transfers the property. Anytime before he transferred the property on March 4th, 2020, he could have come to us instead and said, here's the proposal. You have 30 days.
he didn't. There wasn't a deadline for him to forward upon receiving.
There was not. In some cases, the Blind Monk case that we cited in our reply brief, and I suggest you look at that case. In that one, there was a 7-day deadline. In our case, the deadline is prior to selling the property. That is the deadline. The first 4 words of the right of first refusal says prior to selling the property, he must come to us with his offer. So he could have done that anytime until he actually conveyed title to MBD on March 4th.
Mr. Aiello, we have helped you use up all your time. And I don't remember, I don't think you told me how much time you wanted to reserve.
I would have reserved 5 minutes, but.
Well, I'll give you 5, and I'll give Mr. Elegant an extra 5 so that it comes out even, because, you know, you got interrupted, et cetera. So.
Okay.
All right.
Thank you, Your Honor.
Stop now.
All right. Sure.
All right. Mr. Elegant, you're up.
Thank you, Your Honor. Good morning. Tom Elegant, Buell and Elegant. My partner, Amy Ferrier, is here off camera helping me out. So that it doesn't get lost, I want to touch on the points you've been talking about, because you've suggested another way of looking at the expiration. But there's and I agree, it gets confusing. It's confusing because of the names of the entities, but there's a simpler, at least, way to resolve this. And that is, the law is very clear that NCWPCS did not attempt to exercise the ROFR before August of 2020. Unquestionably, if there was a lease, it ran out in August of 2020. No question that doesn't go beyond that. There is nothing rebutting Mr. King's testimony that he did not agree to it. As you, per your question, they produced no written agreement, written consent. So the lease ends in August 2020. The case law is very clear that you have to have exercised the ROFR by August of 2020. The CSC Service Works case we filed, supplemental authority, directly holds that. The Sternberg case that we discussed in the answer brief holds that. And you'll note there is no response in the reply brief to the Sternberg case. So and there's no difference for this purpose between an option or exercising a ROFR. I mean, when you exercise a ROFR, it becomes an option. So anyway, so that's the simple.
But help me out on one point. This kind of ties into the last question I had right before we switched over to you. How would one be able to exercise a right of first refusal within? Let's go with the idea that August 2020 leasehold ends. How does one even able to exercise a right of first refusal if they're never given notice of it, and if in fact an offer of sale was received while that right still existed?
Yeah, thank you, Art. I'm coming to that. That was my next thing. NCW pled. They're telling you something different on appeal, but what they pled in their complaint, and you go to page 137 of the record, paragraph 34, they plead that the breach was failing to notify NCW in writing of the sale price and terms, ... prior to selling. Failing to notify of the sale price and terms. That is the breach. It's failing to notify. It's not when you sell it later, if you ultimately sell it. If you don't sell it and you've offered it, they could exercise the right to the ROFR. Now, you say, well, how are they to know? Here's how they are to know, Your Honor. The property actually transferred. You heard them say March 2020, which they do because they are in a problem with a year's specific performance thing if it's earlier than that. But it didn't transfer in March 2020. March 2020 was a corrective deed that Keene and D&B gave to MBD to get Crown Castle to pay rent. That's all that was. The actual transfer took place in August of 2019. That's when D&B deeds the cell site to MBD. In October of 2019, MBD sues Global Signal for rent for the easement. Global Signal now is in the position of the easement holder, and they're the ones who are in the shoes of leasing it to NCW. Okay, now, so Global Signal is sued and they respond in December of 2019. So here you are, way before August of 2020. Global Signal knows about it. Okay, Crown Castle is the managing, Crown Castle or CATT, and it gets a little confusing because of the way they structure this thing. But if you look at their pleadings, their own pleadings, pages 131 and 578 of the record, one's a pleading, one's a summary judgment motion. They plead Crown Castle is the parent of CATT. And that a CATT is the attorney in fact for NCW. Now, I don't know if this will work. That's probably too small to, well,
Yeah, it kind of disappeared. It kind of
sorry. Anyway, you've got Crown Castle's the parent of CATT. CATT is the attorney in fact for NWCPS. You're the attorney in fact, you know what's going on. So Global and Crown Castle is also the managing Global at that point. And you can look at 2481 and 2727. So you've got Crown Castle is both managing and the attorney in fact for Global Signal, and who's holding the easement and renting it to NCWPCS, and they're the attorney in fact for NCWPCS. They know they have the same lawyer that comes in December of 2019 for Global Signal is the lawyer who files the suit when they try to enforce the ROFR in March.
So what you're saying, and I'm going to adopt Mr. Aiello's nomenclature, is the tenant got sued by the new owner in December 2019. I don't know if it was an eviction action then or not. Maybe it was for rent, but and at that point, the tenant knows that the property is transferred.
Actually, the new owner, MBD, sues the easement holder, Global Signal.
Which you've gone to pains to show is really in the shoes of the tenant.
Global Signal and the tenant, NCWPCS, and Crown Castle are all, it's like a Charles Dickens novel. They are all related. Okay, they all come together.
I get it. But what you're saying is the tenant, so the tenant would have had knowledge in December 2019.
Exactly. Knowledge to one is knowledge to any. And of course, we have a rule of judicial administration that the lawyer is the agent for the client. So what the lawyer knows, and the lawyer knows in December of 2019 that there's been a sale. Okay. And they don't do anything about it. And
so is the argument then that this requirement to give notice of a sale offer has been waived because they knew that it had sold previously? Is that kind of cut to the chase of it?
I think a nuance to that, Your Honor. Sure, they should have, there should have been notice given in the summer of 2019 for the August sale. Yes. But
and that didn't happen.
That didn't happen. But the law is clear. If you're going to, and they know that didn't happen by the end of 2019, they being this cabal of all these AT&T related companies, because that's what they are. They're all AT&T related companies. So they all know that by the
I don't know. We have to refer to them as a cabal. Maybe we could come up with.
Let's call them a big family in the Charles Dickens sense.
A cohort.
Yes.
There you go.
They're all together. So and they have until, and the only thing they really say in the reply brief or in their argument about that is they say, well, oh gosh, we didn't know the terms, even though the the sale was recorded and you know the price, it was 500,000. They say, we didn't know the terms. We didn't learn the terms till later on. And it was going to be financed over time. And to that, I would say, really? You've got multi-billion-dollar corporations, and whether you could finance it or pay the 500 is going to make a difference.
But the right of first refusal is the right of first refusal. It says what it says, and if you didn't, if your client didn't
Okay, and they
comply with
didn't.
it, then that's an issue. I mean, it doesn't matter how much money and how much juice they've got if either got complied with or it didn't.
Right, and had they said by August of 2020, look, we wanted, if had they filed their suit that they filed in March of 2021, by August of 2020, we'd be having a whole different discussion. Probably wouldn't be having a discussion, but they waited too long. Actually, we would because of the breach and because of the lease running out and that kind of thing. But it would be a different discussion. This wouldn't be an issue. This is the easy way to get there because the law is clear. They have to exercise it by August 2020, and they didn't. Now, as to go back and respond to a couple of the points that came up, I do like the alternate.
Well, let's come back. You're saying by August 2020, the property's been transferred. So you're saying they needed to exercise the right of first refusal by then, or sue for the right to do so.
Yes.
By August 2020.
Yeah. Yes, Your Honor. They sued in March of 2021.
Right.
So they can't say, oh, by August 2020 it was.
Which they contend they had a lease until 2037.
Well, that's clearly wrong. They don't have any written approval to that.
There's nothing really clear about any of this.
Well, I think the agreement is clear that as per the earlier questioning, that they can't cut off, or that it can't be extended without written consent. There is no written consent. They have none. They've had years to get it. And that's the other thing. They could have taken discovery. There was a pending case. They could have, from December of 2019 to August of 2020, they could have taken discovery and gotten the terms if those were important to them. They're not important. Point is, they don't act by August of 2020. They're done on that because the ROFR has expired in the best view of the lease expiring for them. Okay. Now let's come back to what we were talking about before. They're trying this business about Keene accepted the benefits of the illegally extended lease for 13 years. Well, first off, it was going to be extended to August of 2020. That's what it says, even without his consent. So that's not accepting any illegal benefits. And their own, we've cited this in the brief, and their own representative testifies that simply getting rent, even getting increased rent, doesn't tell you the lease has been extended illegally. Okay, so because one of the things that the Global Signal or its predecessor was supposed to be doing with the easement was getting more people on to the tower, so you would have increased rent there. So Mr. Hagee admits, I can find that site in his deposition at 2530, that increased rent didn't tell him about the illegal extension. Okay, so that I hope that disposes of that. This business about how is the poor tenant, how's poor NCW PCS supposed to know what's going on? Well, aside from the fact that they're all related, how are they supposed to know that this was an illegal extension? It was actually their predecessor, but that they acquired. It is, as somebody mentioned, it is recorded. The easement is a recorded document. So yes, they could go look at that. What is not,
but what, before you, and you still have plenty of time, but I just wanted to be sure we're on the same page here. You are not proceeding with the argument that the basis of the judge's ruling prior breach by the tenant is a proper basis for this summary judgment?
Yes, we think that's another alternate ground, Your Honor. We think there are three.
So tell me how the tenant breaches an agreement that the tenant is not a party to.
Okay, Your Honor, we've cited the cases.
How that becomes a breach of the tenant's lease.
We've cited several cases at pages, I think it's about 29, let's see, 26, 27 in the brief, that holds that you can't do what NCW PCS says it did here. This is and I hope I'm not going back too far in time. This is the Sergeant Schultz defense. I know nothing. Okay. Yeah. It's publicly recorded. They know about it. And so they know that when they sign that extension, they are facilitating the easement holder from breaching that contract. And the cases we cite at 2627 says you can't benefit, you, the party who is purported to benefit from that, you can't benefit when you have participated in that like that. And there's a number of cases, they're in different contexts. There's no case just like this. Neither side cited a case just like this on that point.
If there
We've cited
is a
cases
case just like this, I hope it never gets assigned to me.
You know, there is no case just like that, but the cases stand for the proposition you can't sit by and go, okay, well, I know they're breaching this. I'm going to now take the benefit of that breach with my contract with the breaching party. Can't do that. And it makes sense that you can't do that. And that was a rational basis. I do think the the lease expiring in August 2020 is the much easier analytical route to go. I would agree with that, or I would offer that. Okay, so again, the lease, and again, the lease is not recorded. There's no testimony anybody gave that lease to Keene, told him it was lease extension, that it was extended beyond what he had authorized in the easement agreement. So the reason they're hung up on the one, and I would point out, if we agree, the court agrees that you can't, that the ROFR wasn't exercisable after August of 2020, we're done. We don't have to get to the other issues. We don't have to get to the specific performance issue. If you agree on any of the three things we've talked about for issue number one, in other words, whether it's first breach or the lease was no longer effective or it expired in August 2020, any of those, we don't get to the second part. The second part is where they get concerned about specific performance. And that's why they want to say, oh, it transferred in March of 2020. It didn't. I mean, if you look back, and we've done the comparison in our brief, if you look back at the deeds and the language, they're misreading what happened. The property was fully deeded to, well, let's take a step back. In 2015, Mr. Keene quitclaimed the full 10 acres to D&B. Okay. He then quitclaims.
Is that the deed where Mr. Aiello in the reply says there was a cutout for the acre that the cell tower sat on?
No, what I think what he's referring to there is come the next year in August 2016, there's a sale of 9 acres to D&B. Excuse me, a sale of 9 acres to KB Homes, and they wanted, I guess, because it wasn't.
No, I remember. Then they basically communicated with the tenant and said, or tenant's attorney said, would you want to exercise your right of first refusal at that point? And the tenant says, we're only interested in the acre, not the 9.
Right.
You contend that the whole 10 had been transferred previous to that.
But they have been, unquestionably. The full 10 is transferred. If you look at 24, 28, and 9, the Keene quitclaim deed is for the full 10 acres in October 2015. When we get to August of 2016, I guess D&B wanted, or excuse me, KB Homes wanted something clearer. So they had Keene quitclaim 9 acres to D&B, the same 9 acres that are part of the 10. And then that's what is deeded to KB Homes. But, and they're trying, and if you look, they're confusing. There's a line.
And remind me again what the who the parties were to the 2015 transfer.
Transfer Keene individually quitclaims it to D&B, D&B. Okay. And from then on, D&B owns it. D&B owns it, the whole 10 acres. Okay. So that's why when D&B deeds.
Is D&B his business, his entity? It's
yes.
he has a bunch of entities, and that's one of them.
Okay. I don't know if he has a bunch, but D&B is something that he deeded that property to, and then that is D&B is who deeds the cell site in August of 2019 to MBD. So I know a little confusing, but less confusing than all the others, I hope. So and we've done this, I think, in the brief, but they're trying to rely on some language that says less the cell tower site. In describing one of the deeds, that is referring to, if you look at where that is, that's referring to an easement. When the when the property is being transferred, it is a different wording that you would expect to describe property. It has a description of the property. So, yeah. Both 2016 deeds have the less from all lands described with a legal description, and that is what is taking out the 1 acre cell site. That's how you exclude a parcel of land from a transfer, not by saying just less the cell tower site. If you look at where that comes as part of the easement language in, for example, the 2015 deed. So that, you know, and the only reason they're concerned about that, or the reason they're concerned about that, is because if the property was transferred in 2019, they can't have specific performance when they file suit in 2021 because it's more than a year. I say we hopefully don't even reach that issue, because under the first part, they haven't exercised the ROFR by August of 2020 under any view.
But they don't they still have a damages claim? You know, if you got a 1 year specific performance bar, but that's a remedy. That's not.
They would still have it if they won in the first issue and lost on the specific performance, they would have a damage claim. I'm saying you don't even get to the specific performance claim if in the first issue you say, well, they didn't exercise it timely, so we're done. And that's, again, that is whether you look at it as they didn't exercise it timely because they waited till after August 2020, or the extension past 2007 to 2020, as you suggested earlier, doesn't allow the ROFR to continue to be exercised. Either one of those routes gets you to the same place, and that they do not have, NCW PCS does not have a right of first refusal that they timely exercised. I'm happy to try to answer any other questions. If not, we would ask that you affirm.
Thank you, Mr. Elliott. Mr. Aiello, you have 5.
Thank you, Your Honor. First of all, to go back to something that Judge Lucas mentioned, would there be any distinction based on the circumstances that we saw if the lease was construed as a month-to-month from 2007 forward? Well, the rent was increased significantly, like 50% in that lease extension, and that's the rent that was paid after 2007. So, you know, everybody who was involved would have known this is pursuant to this new lease extension. Keene was receiving more money. Obviously, the agent knew that they had signed that lease extension, but it isn't the same as a month-to-month, which would have continued at whatever the same rent was before. So the parties acted under this lease extension, which Mr. Keene never even sought to see, never did anything to see, nor did his lawyers. He hired the agent. He chose to trust the agent. If the agent didn't get his permission, that was a breach by the agent. All the parties proceeded under the lease extension for 13 years. It wouldn't be fair to the tenant to say, now, when we can't go back to 2007 and renegotiate, now you're responsible for the agent's failure to get the landlord's permission, and so your lease is essentially void ab initio, and you were proceeding under a common law theory, and then you don't have a right of first refusal. The law seeks to be fair and equitable. That would not be fair and equitable when the landlord did nothing at all to protect his own rights, and he's a party to the agreement. He's a party to that lease agency agreement. Second of all, the argument that the tenant did not attempt to exercise the right of first refusal before the lease expired. You don't have to exercise the right of first refusal before the lease expired. Lease expiration is the deadline on there being a trigger, meaning an agreement to sell. Prior to selling the property, if there's an agreement to sell, the landlord then must extend that offer to the tenant. If that happens the day before the lease expires, that doesn't mean that the tenant has 1 day to file suit or to accept. He still has 30 days because that's the terms of the right of first refusal. If the landlord doesn't do it and breaches, now we have a breach and the statute of limitations is applying. And so if the lease expires during the statute of limitations, which the other side is saying that happened here, that doesn't change the statute of limitations. The statute of limitations under the Florida statutes doesn't get shortened because a contract expired. Many contract breaches happen before a contract expires, but that doesn't mean you don't have a cause of action. The statute of limitations determines that. So if the breach occurred on March 4th, 2020, when the landlord did not extend the opportunity to the tenant to buy under the right of first refusal, the statute of limitations began running that day, and on specific performance, it ran for a year. And as you said, Judge Northcutt, on damages, it would run for, in this case, 5 years on a written contract. Counsel argued that this property was really transferred in August of 2019. Our brief does cover this, but that was a deed from DNB to MBD. DNB did not own the property at that time. The real property transfer was when Keene transferred it on March 4th, 2020. That's what ended the ability of Keene to perform under the right of first refusal and began the statute of limitations. Defense depends on this deed that they say in 2015 deeded the entire 10 acres. We cover that in our reply brief. It's not true. The deed in 2015 said less the cell tower site. The defense tries to explain the language there as meaning what it really means is the easement is excluded from just the cell tower site. That doesn't even make any sense. Keene was dealing with a company called KB Homes even in 2015. The reason he deeded the acreage to his company is because he wanted his company to be the grantor. Remember, that cell tower site was still subject to that easement agreement. There's no reason to transfer that away, or now it comes out from under that easement agreement and probably has a breach against CTLA. So to clarify, the clarifying deed was between the same parties in 2016 and makes very clear what the phrase less the cell tower site means. It deeded to DNB from Keene the 10 acres less the legal description of the cell tower site, which matches the site that's in our site lease. So it's clear that all that Keene transferred to DNB in 2015 and 2016, it was just a repeat deed, was the 9 acres that he was selling to KB Homes. DNB was not the owner of the cell tower site in 2019. They did not own it. That's why Keene had to transfer the cell tower site in 2020 on March 4th.
You need to wrap up, Mr. Aiello.
Okay, I do. And when we've talked about the cases, the supplemental case that talks about exercising the right of first refusal before the lease expires, you'll see in that case, the lease expired in 2014. The right of first refusal went to 2015, according to its terms. The tenant didn't try to exercise until 2016. There wasn't a sale until 2016, so it didn't apply because that triggering event didn't happen within the term of the written lease.
All right. Thank you both very much.
Thank you, Your Honors.
It is an interesting case, maybe a little too interesting. But you know, hey, we're open for business and we take it all. So in order to leave our virtual courtroom, you need to click the button on the Zoom screen called Leave. It should be in the lower right, I think. And you go off into the ether. There you go. All right. Thanks much. Okay, our next case. On.